Hi, everyone, and welcome to AIADA's Auto Talk. I'm your host, Rachel Soleimani. As a reminder, anyone that has registered for today's program will be receiving a copy by early next week. Joining us today, we have Brad Miller, CEO and Chief Legal Officer at ComplyAuto. Brad, I know there's a lot to get to and to catch us up on today, so I'm going to let you have the floor.
Okay, awesome. Well, thank you very much, Rachel. Thanks to AIDA for hosting us today. Well, Rachel and I were talking that it's a little fortuitous because we had sort of talked about this issue even before the recent FTC activity. So very, very timely webinar. I've been speaking to groups of all sorts about this. Lots of interest in it from the dealer side. I've got a bunch of slides, maybe in some cases a little bit more than I can really give full credit to, but I wanted to give you all the information I could give you and leave as much time as we can for questions, because I'm sure there will be a lot of questions on this. This is a not only timely, it really is a material change, certainly in thinking, certainly in practice for dealers. And I'm going to sort of walk you through what happened, why that is, and sort of what you can do going forward. So we're here today talking about advertising compliance, largely the question of vehicle price disclosures, dealer fee disclosures, and similar issues in light of what the FTC has done recently. So let me move my slides here. So I am Brad Miller. I work at ComplyAuto. Been here a couple of years. I spent about 16, 17 years before that at ADA, most recently as Chief Regulatory Counsel there. So I have a long history sort of in the dealer advocacy space, been working with the FTC on federal advertising issues for nearly 20 years. And so have some background. And I will tell you, in my opinion, this is probably the most sort of fraught environment, enforcement environment that I've seen. There have been sort of sporadic enforcement activity over the years. The FTC has attempted some rulemaking. We'll talk about that. But this is really the most really concentrated and clear signal from the FTC that I've seen in 20 years in terms of enforcement. We'll talk about some of the things that are going on in that case. So I am CEO of ComplyAuto, and if I am a lawyer, so I always have to give the disclaimer. I'm a lawyer, but this is not legal advice. This is, we don't have an attorney-client relationship, but obviously we're going to be covering a lot of important compliance issues. If you don't know ComplyAuto, we haven't been around that long, but we've got over 10,000. I think it's actually over 11,000 dealers now that we work with in all 50 states. We work with most of the state associations and our affinity provider with NADA. And a lot of our folks really came from the dealership world, right? That's kind of why we're able to do what we do. We have the best legal and technical minds and also some real dealer experience. So if you don't know about us, give us a call, reach out. So, okay, we're going to talk about federal advertising issues. Look, there's a lot to cover here in terms of broad federal advertising law. I'm not going to, I will touch on it for just a minute, just to level set, but really we're going to focus on what's been happening at the enforcement level, both federally and at the state level, and then, of course, the FTC letters that came out last month. I do have some examples, which people always ask for and seem to appreciate. We actually put out an advertising guide. I have a link at the end if you want to download a free copy of the advertising guide that we put out that has a bunch of examples in it. But then we'll obviously have time for your questions. And I think Rachel's going to be watching the questions. I think Rachel, I don't know if they put them in the chat or the Q&A, but she's going to try to ask them as appropriate as we go through. Okay, so I feel like I need to level set a little bit with you. Again, I'm not going to have time to sort of talk about federal advertising overall. But keep in mind that dealers are regulated both at the federal level and at the state level, and in some cases even at the local level, right? If you live in a big metro area like New York City, somewhere like that, there are even local advertising laws that dealers sometimes have to worry about. At the state level, obviously, there's a whole statutory regime. The AGs put out guidance. You may have a dealer. Or a committee of dealers or other regulators that regulate advertising in your state. There's a lot of different flavors of that. But at the federal level, the primary enforcement agency is the FTC, which is the Federal Trade Commission. So the Federal Trade Commission has been around a long time, probably nearly 100 years. And in the legislation that set up the FTC back in the 30s or the 20s, whatever it was, I think it was the 30s. The original grant of authority included something called Section 5 of the FTC Act, which basically allows the FTC to bring enforcement actions and to enforce activity that they think is unfair or deceptive. So you may have heard of UDAP. That stands for unfair or deceptive acts or practices. That's a very, very broad grant, right? I mean, there is some case law, there's some statutory authority, and some other guidance on what exactly those words unfair or deceptive mean, but it's really very broad. And the FTC has brought enforcement actions against dealers, against all sorts of businesses for a whole variety of issues under the Section 5 of the FTC Act, including advertising. Lots of activity, including specifically dealer advertising. I would say, we'll talk about some examples just from the last few years, but over the last few decades, there's probably been hundreds of cases, enforcement actions brought against dealers or specifically for advertising violations. So the primary source of authority is just the FTC looks at an advertisement and says, the way you're doing that's unfair or it's deceptive to consumers, and we think it's illegal. Okay. And we'll talk mostly about that today. I do note there is one other federal statutory grant of authority the FTC gets. Remember, the agencies can only do what Congress says they're authorized to do. So the FTC has this broad grant under the FTC Act. There also are two different statutes, TILA, which is the Truth in Lending Act, and then its implementing regulation, which is Reg Z, which governs credit advertisements. So if you're advertising credit, TILA has provisions in there that are statutory that basically say it's called trigger terms and follow-on disclosures. I may have a slide on this. If I don't, I always mention it because dealers always fall down on this, and it's just an easy thing to get right. So just don't forget it. If you have a credit advertisement, it's TILA and Reg Z. If you have a lease advertisement, it's Consumer Leasing Act and Reg M. But in both cases, what the federal law says is if you advertise certain terms, like, for example, a monthly payment or a total amount down, then you have to make sure that you also include what's called follow-on disclosures. So if you say the monthly payment, you also have to say the APR and the number of payments, et cetera, et cetera. So that's a rather formulaic piece. We're not going to spend time on it today, but I always wanted to remind people because in these enforcement actions I'm going to talk about, they almost always bring claims for these trigger term follow-on disclosure violations under TILA and Consumer Leasing Act. But that's it. That's the federal statutory regime for enforcement against advertisements. Now, the FTC obviously has the broad grant. They do sometimes try to give guidance in terms of what they call guides or even rules. So they pass rules. So, for example, they don't do it very often, but the used car rule is a rule from the FTC. The reason we put those buyer's guide on the used cars, that's because the FTC issued a rule because they thought the way the dealers were disclosing their warranties was deceptive. So they said, here's a rule. Here's how you disclose the dealer warranty. Here's the buyer's guide. They also tried to pass a rule, as you may remember, a few years ago called the FTC Cars Rule. And NADA called it the vehicle shopping rule because CARS is this acronym that's combating auto retail scams, which is derogatory, of course. That was fought and voided. And we'll talk about that in a minute. And then they also have recently passed a rule called the junk fees rule. Now, that is a rule that exists. Importantly, it does not apply to dealers directly. But I'm telling you all this because, frankly, and let's talk about the CARS rule for a second, and I'll sort of tell you why I'm saying all this. The CARS rule was, as you may remember, this is supposed to go into effect about a year ago. NADA sued and won, and it was withdrawn. But the bottom line that I want you to understand about this is the CARS rule is not in effect, but the FTC has consistently said that all the things the CARS rule said you were supposed to do were really just a way to put all existing requirements into a rule. And so they're saying, look, all this stuff's already required. We were just sort of putting it in a rule so that we could get penalty authority against you. And the court itself didn't say, hey, the FTC is not allowed to enforce these things. They just said you failed to follow your procedural rules, and that's why we're striking the rule down. So my point in telling you that is if you remember what the CARS rule would have required, which was advertising and disclosures and a whole bunch of new obligations for dealers, the FTC really has taken the position that that's always been the rule and still is the rule of the law of the land. So it's important for you to understand. I'm not saying the CARS rules in effect to dealers. Don't get me wrong. Brad didn't say CARS rules in effect. What I am saying is the FTC's perspective is all those issues are still illegal under their broad UDAP authority today. Then there's the junk fees rule. I think the new administration changed it to the fees rule. They call it just deceptive fees rule. This only applies to lodging and ticket sales. But look, the reason I'm telling you about all this is because there's been a multi-year focus on advertising, and does the advertising include all the fees that are in the cost? So, for example, you go to a hotel, they advertise a price of $199 a night. You go to check out, and it's $329, right? Because they got a $60 resort fee and a gym fee and all these fees, right? The FTC has said we think it's de facto deceptive to advertise a price that doesn't include all of the fees that someone has to pay to get that product or service, right? So this is going to sound familiar to you in a minute with these letters, but they've brought a bunch of enforcement actions. You can see these are not dealer enforcement actions, but this is actions under the junk fee rule for lots of money. Those are big figures, right? $60 million and $24 million. They are on a warpath in all sorts of industries to remove fees, undisclosed and required fees from the advertised price. That's the bottom line. Meanwhile, what are they doing with dealers? So I put this, I know this is a busy slide, but it's just to give you visually a sense of just in the last few years, this is a sampling of some of the enforcement actions that have been brought against dealers. A few things to note here. First of all, I think we see sort of a marked increase in the numbers. They keep going up and up and up. They almost always work with the state. There are a few that are just the FTC or just the state, but mostly it's the FTC working with the state attorney general or the state authorities in some way. And there are a couple reasons for that. One is they get additional claims under state law. They also get the ability to bring higher damages many times under state law than they can under federal law. But the bottom line on this is they've been very active. These are all different. But at the end of the day, the bottom line in these cases is almost always advertising a price that doesn't include all of the fees that the consumer's required to pay. Now, it's that plus it's F&I practices, right? So you lure them in with a quote unquote deceptive ad, and when they get there, then you allegedly engage in things like payment packing or deceiving people into thinking they had to buy products, things like that. That's there's differences in these cases, but in almost every case, that's what's at the heart of it, right? So here's the slide. So it's got price advertising. It's got product sales practices once they get in the F&I office, things like payment packing. And then they also throw in, this is why I mentioned this, Reg Z or Reg M trigger term violations. So again, I'm not saying you do these things and you're all set. I'm saying this has clearly been the focus of what the FTC has been bringing these enforcement actions in for the last few years. And you may have noted that was a lot of those were under the Biden administration, but many were also under the Trump administration. The last sort of preliminary thing I want to mention to you is, and this is a real change in my mind, and it's a very intentional change, in almost every one of these cases, there probably were a few where it didn't happen, but most of these cases, and certainly in a lot of the big ones recently, the FTC brought the action not only against the dealership itself, but against individuals. So the individual dealer principal. So it's not just against Miller Motors, the dealership, it'd be against Brad Miller as an individual. Also sales managers, general managers, and finance managers. If they are the ones involved in the practices in the F&I office, then they are being individually named in these cases. This is an example here of a recent Connecticut case. And I note it because they, as you can see, they sued not only the dealership, but 4 or 5 individuals, and they've settled out with a few of the individuals, but litigation continues against both the dealership and certain other people. So they are naming individual people as personally liable for these violations, and they're really aggressively litigating these claims. So it is a way. It's been this way at the federal government level in a number of areas. They see this as a very powerful way to hold individuals accountable, to get people's attention, to make sure that they understand it's not that you can engage in behavior and then you can just go get a job somewhere else, right? Your employees, you individually are going to have a problem potentially yourself. Okay, so with that dire news, what is the big thing that's happened recently? So really what happened, the big bomb that they dropped, remember, I gave you that background, that 10 minutes of background, just to say, look, this has been bubbling for a long, long time. They've been saying over and over again, we don't like, they used to call it drip pricing. Then they call it junk fees. They try to pass these rules. They keep saying, look, and then they bring enforcement actions again and again and again. And they're saying, hey guys, we're trying to tell you, you need to disclose all these fees in the price, right? Then about a month ago, they send this out. So they sent 97 letters to 97 auto groups, dealer groups nationwide. Now it's not public who they sent them to. It's starting to come out a little bit in places. I think they were generally larger groups, but not exclusively. They were all over the country, right? I think that was probably intentional, try to get one in every state in the union. And they sent these letters to them. And what did the letters basically say? Oops, I think I took out that slide. But the letters basically said, look, we are telling you 97 groups that your advertising is illegal. And there are 6 specific things they said were illegal about their advertising. We'll cover those in a minute. But there were 6 specific things that were illegal about your advertising. And also, we are telling the entire auto dealership industry that we are going to be bringing more enforcement actions in this area. So these letters are not necessarily enforcement actions, although I understand there are some enforcement actions that have gone out in conjunction with the letters. But they're letters saying, hey, 97 groups, we're telling you your advertising is illegal. And by the way, we're telling the entire dealership industry that this kind of practice, we're going to be bringing enforcement actions against you if you do it. Okay? Let me come back to that. So what do they require? Basically, that advertised prices include every fee consumers will be required to pay to purchase the vehicle. Right? There's more than that. We'll get into some more details, but that's the main issue. It's your advertised price has to include dock fees, has to include shipping fees. It has to, whatever you call them, bank fees, prep fees, whatever they are. If someone has to pay them to buy the car, it has to be in the advertised price, the top line, most prominent advertised price. Okay. And again, no mandatory fees, add-ons, or financing conditions are concealed until the consumer reaches the final stages of the purchase. They don't like the fact that if you advertise a car for $50,000, that I can't come in and give you a check for $50,000 plus tax and buy the car, right? And they don't like the fact that you get all the way through the process, and at the end they say, "Oh, by the way, there's an $8.99 dock fee, or there is theft deterrent on here, and it's $99 a month, whatever it might be." So you gotta. There's more to it than that, but you have to put the price in the advertised price. I skipped this ad. I mean, skip this slide. I just note this. I probably should have taken this out, but I get this question all the time. Hey, the Trump administration's now here. I don't have to worry about this stuff anymore, right? I thought they were deregulatory. I thought they were. Look, the Trump administration is probably deregulatory in the sense that they are not going to be passing new rules, but they've made it very clear that they are willing and able and interested in enforcing existing rules. And by the way, the states are both enforcing existing rules and making new rules. Some of you, if you're in California, you may know that California has passed their own version of the CARS Act. It goes into effect in October. So the states are really picking up the rulemaking and they're in the regulation. But even at the federal level, they're likely to be increasing in their enforcement, not decreasing. And I'll tell you this, I've been involved in a lot of conversations in a lot of states in this country in the last few years, in both red states and blue states. And it's unfortunately sort of a bipartisan issue. They both are kind of upset about dealer advertising practices, and they're really coming after dealers. Okay. So the letters. Okay. So, all right. So I've just talked for 10, 15 minutes, setting it up, telling you what happened. What did they say was the problem? This is what you want to know. There were 6 things that they listed in these letters that they said are now, by the way, they didn't really say we're now saying it's illegal. Like their perception of this has always been illegal. We're just clarifying that this is specifically something we're going to be bringing enforcement actions for. So in their mind, I don't think they think this is a change in the law, although I think in a few cases they're a little mistaken. But regardless of what it means, they've made it clear if you do these 6 things, it's going to be illegal. it is illegal in their eyes, and it's likely to bring an enforcement action. So what are they? You can read, and by the way, I'm going to have slides on each of these, so I'll go through each one. But the little note at the bottom, they made it very clear also. These are just examples. So this is not an exhaustive list. Doesn't mean they're not going to bring an enforcement action for something else that's similar or also problematic. But these are the ones, obviously, they're focusing on. These are the ones you have to get right starting today. And this is not like they said you have till July 1st to comply. They're saying, look, this has always been the case, and you better be doing it now or you're going to have a problem, right? So this is not a change, a new rule, something you have to do it in the future. This is something they're saying, hey, this has always been the case. We're just putting you on notice. This has gotten so bad. We're telling the industry we're going to start slamming people with some enforcement actions right now, and you got to change your practices. Okay, so what are the 6? Let's take into them a little bit. Keeping an eye on the clock here. So this is the biggest one. I know you're going to hear me say this probably 10 times, but it's advertising a price that doesn't reflect all the required fees. If you do that, they consider that illegal and are likely to assert that it's illegal against you. Now, can they bring an enforcement action against every dealer in this country? Probably not. But I hope. But believe me, when their bazooka is aimed at you, it's a big deal. It's expensive. It's tough. They issue what's called a CID, a civil investigative demand. It's very onerous. It's like, subpoena on steroids, and it's very expensive. And they, like I said, they name individuals and they extract these settlements for a lot of money with 20-year consent decrees. So it's nothing to mess around with. So again, I'm not in the business of sort of overblowing regulatory risk, but this is, they can't make it any clearer that they take this very seriously. So what does this mean? The biggest headline item here is that this means the doc fee has to be in your advertised price, right? I don't know what states everybody on the line is from. I can tell you probably 20 states already have laws in the books saying that your doc fee is supposed to be in your advertised price. Were dealers doing that in those states? Largely not, unfortunately. So that's been the law of the land in many states already. But regardless, the one thing the FTC has clarified, they had a follow-on webinar with the NADA, and they clarified that regardless of what your state law says about doc fees, that has to be in the price. The doc fee has to be in the price. Doesn't matter if your state regulates doc fees, doesn't regulate doc fees, allows you to disclose the doc fee separately, or requires you to disclose it separately. Doesn't matter. Has to be in the price, the total price. So if the car's $50,000 and your doc fee is $499, it has to be $54.99 is the advertised price. It can't be $50,000 with $499 in the fine print below. Same thing with destination charges on new vehicles. There actually are most states already require that to be in the price on a new car or truck, but there are some states that allow you to disclose it separately. You cannot do that anymore. You have to have anything that a person who wants to buy that vehicle has to pay, has to be in that upfront price. Doesn't matter if you call it a service fee, a processing charge. I can tell you we have a product called Guardian. I'll mention it at the end. But we look at tens of thousands of ads all over the country. We see all sorts of terms. These are real terms we've seen in dealerships for fees, right? Service fees, processing charge, filing fees. You can read the list. Doesn't matter what you call it. If you have to pay it, it has to be disclosed in the price. Doesn't matter if you disclose it in the fine print. Doesn't matter how you disclose it. What matters is it's in the advertised price from the FTC's perspective. You still could have some state law obligations you need to worry about in terms of disclosing or breaking out the dealer fees or calling it a certain thing, but it has to be in the price. Okay, so that's a big change, obviously. That hits a lot of people where they live, and that's going to require a change in practice at a lot of dealerships. I will tell you, like I said, we monitor tens of thousands of dealer ads, maybe hundreds of thousands, and I've been impressed at how quickly I've already seen dealers changing their practices and clearly including all dealer fees in the price. And they make it. You can say, "Hey, advertised price $50,000." In big bold letters, it includes all dealer fees. Pay nothing more. Nothing more than taxes. You can say whatever you want as long as the top line number has all these fees in it. Okay, so it does. There are some things, as always. There's always exceptions. It's not 100% of what a person pays, but it's everything that's required by the dealer. If it's optional, then you don't have to. include it, but of course that has to actually be optional. It can't be just a product you put on there and then you require them to pay it later. But you can exclude taxes, title, and reg. So I get the question all the time because they say you can exclude government required fees. Well, yeah, well, my state, regulates my doc fee or sets my doc fee. Doesn't matter. Not the doc fee, just taxes, title, and registration that can be excluded. Okay. So anyway, I belabor that a little bit, but that's probably the biggest issue. I'm sure there'll be questions on that from some people. I've seen a lot of creativity and people trying to sort of think of ways around this. But remember, the issue here is they want a person. They hate the fact that a person drives to a dealership, maybe an hour away based on an advertised price. They get there and they find the price is actually higher than what was advertised. That's what they're trying to avoid. And so if it's a required fee, they can always choose to do more and pay more if they want, but you just can't have a fee that's not an advertised price. Okay, I think I've beaten that horse a little bit, but that's the biggest change, I think. And again, from the FTC's perspective, it's not a change. They're just clarifying what they think has always been what you need to do not to be deceptive. Second big one, advertising a price that reflects rebates or discounts not available to all consumers. Now, this I think I would argue is a slight change. I think you could have argued that under previous FTC enforcement actions, they would say things like, as long, it had to be available to most consumers, the typical consumer or something like that. Now they're saying, no, that's not the case. It has to be available to 100% of the people, right? So, customer cash, if it requires you to finance through, Honda Finance, then you can't put it in the price because it's not available to 100% of the consumers. Okay. So remember, you can list the rebate. So you can say a car is $50,000, and I do have an example of this later. Car is $50,000, and by the way, available $1,500, customer cash, $2,000 first responder. Blah, blah. You can list them all. You need to put a little parenthetical saying what the qualifications are, but you can't then do the math. You can't then put a big headline number below that says 46.5 or whatever. In the CARS rule, they call it factoring it into the price. You can't sort of do the math and add it in. You can say they're available, but unless they're available to 100% of the people, 100% of the time, you can't take it out of the price. Okay. Remember, that applies to rebates and discounts. I'm not 100% sure. I mean, obviously, it doesn't have to be just an OEM rebate or a finance company rebate. Any dealer discount that you advertise, you can advertise. You can say the Miller Motors discount on this is $1,500, but that has to be available to 100% of people. And we'll talk about some issues with that too. So that's number two. Number three, advertising a price that fails to account for an additional required down payment. Look, this one, I would argue this one's pretty deceptive even before this letter came out. In other words, your car's $50,000, but you advertise it for $45,000, and in the fine print you say assumes $5,000 down payment, right? It's really a $50,000 car, right? So they made it very clear you can't bury a required down payment in the fine print. You can't do a guaranteed trade-in allowance, all those kinds of any consideration. By the way, guaranteed trade allowance has all sorts of other issues because it's sort of just inherently deceptive because some people have trades, etc. But you can't do that. This is a practice they specifically called out with these 97 dealer groups, and I would avoid it at all costs. Three, conditioning the advertised price on a consumer using dealer financing. So look, this one I think has been growing a little bit the last few years as a practice with dealers. I get it. You want people to finance through you. You make your money on the F&I, and you have an incentive to do so. You can do all that, and you can incentivize people. You can sell your products as much as you want. You just can't say the $50,000. You can't advertise a $50,000 car as 48,000, and then in the fine print say that assumes that that requires you to do finance through the dealership, and that includes things like captive financing, things like that. So again, you can tell people it's available, but because it's not available to everybody, like if someone walks in and wants to write a check, they don't get that discount, so you can't put it in the advertised price. Okay, that's one they called out. Number five, this one's a little bit more complicated. it's requiring consumers to purchase additional items not reflected in the price. Look, what the main thing they're trying to get out here is, I advertise a car for $50,000, and then in the fine print it says, I don't want to pick on anybody, but it's like, low jack $699, window tinting $599, whatever, tire and wheel protections $399, and it's required. It's a mandatory hard ad that. So when you walk in, you can't buy that car for $50,000 because you got to buy the mandatory add-on products. So this gets a little bit unclear. I have another slide just to help you try to walk through it. But look, we kind of know the difference between a mandatory ad and an optional ad, hard add-on. Look, if it's a lift kit, you can't. Everyone always asks, well, what if I take it off? If it's not required, I'll take off the low jack, or I won't turn it on, and I don't charge them for it. Well, if that's really true, then that's really true. But I have to, ask yourself, is low jack on 97% of your deals? I mean, is that really optional? You're gonna create an issue otherwise. So you can always sell these products. There's nothing stopping you. This is all about the advertised price, right? If it's required to be purchased to purchase the vehicle, then you got to include in the price. I think hopefully you get the idea. I do get a lot of good questions about this. Look, this is the advertising is the first half. The second half are the F&I product practices in these allegations almost every time. So I didn't mention, since that letter came out, there was another enforcement action that got the headlines against a Maryland dealership group because of the number. I mean, it was $78 million in restitution and fines. And in large part, I think these numbers got so big because at least the allegations were the F&I product practices that they engaged in were they were related to the advertising, but they were also an additional problem, right? It's like basically every time there's an allegation, consumers said, they told me I had to buy the product to qualify for financing, or I had to buy the product to buy the car, or it was required, or I didn't know I bought that, and they hid it from me, right? I don't know if it's true or not, but that's what the consumers allege, and that's what the FTC says. So look, this is the products are an area of danger in lots of ways, but the key here is don't advertise a price that doesn't include a hard add-on. Okay. Here's a slide again. Take a look at this when you can. You'll get these slides if you want. So many questions. Maybe this will help you try to understand the difference. I think most dealers get it, but look, if it's a tangible item that's on the vehicle, pre-installed, probably going to be required. Services probably going to be optional. Gap agreements, service contracts, those are optional add-ons. I guess I could see if someone requiring you to get a gap agreement. I don't know, but anyway, do you remove it generally? Just because you removed it 1 out of 100 times, is that enough? Probably not. I would say it probably isn't. The fact that you can remove it, I mean, that's fine. I could remove window tint theoretically, but it's very hard to do, and it's cost me more. I won't get into this. Look at this when you can, but if you have some questions in your own practices about what this means, this may help you a little bit. And then what do you do? I mean, look, this is a big deal independently. I can tell you some of these practices. I mean, payment packing. I've done. There are lots of allegations in these claims of things that are essentially payment packing, and I've done a lot of sessions on that. And there's a lot of confusion of people like, yeah, look, is that really even illegal? I told them eventually what they had to pay for it. The answer is yes, it is, and it's a pretty serious issue to sort of be engaging and sort of hiding these things, putting leg in the deal, whatever it is. Having a desking sheet that's burying product in it in a monthly payment to try to make it easier to sell. I mean, I get it to a degree, but I will tell you this is a pretty serious one, and to the extent there's any confusion among your people, you really got to train them. You got to make sure they're not saying things to the contrary too. Like I said, in every one of these cases, there was a salesperson that said something, at least allegedly said something really sort of dumb, right? It's like a salesperson who said, no, you have to buy it to qualify for the financing, right? Well, clearly that's not true, right? Or it's required to buy the product when it really isn't. So you got to document what you're doing. You have to have tools and systems in place. I would get a lot more focus on disclosures. You want a monthly payment with the products, monthly payment without. I want initials on both, whichever one they chose. Make it very clear, right? So I don't have time to get into that now, but I don't want to overlook the fact that this is not just advertising that's leading these issues. It's really F&I practices as well. Okay, last one, and I'll get to questions. Is advertising unavailable or non-existent vehicles. Now, this one's look. I think what they're trying to get at mainly here is a practice that does happen, although I would argue it happens a little bit more at the independent dealer world than the franchise world, of advertising some low cost price leader vehicle that's not even there, right? It was sold 6 months ago, or it never exists, or whatever the case may be, just to get people in the store, right? I can tell you in some of these enforcement actions, they actually had salespeople say things like, "Oh, we don't actually sell anything for that price. That's just to get you in the store." And literally, they told people from the FTC this, right? So obviously, that's what they're trying to get at, and you shouldn't do that. You can't advertise a vehicle if it is not there and you are not willing to sell it at that price, right? That said, I will tell you one thing, because the one question on this in particular for franchise dealers is in-transit vehicles. Obviously, there are a lot of dealers who advertise vehicles that aren't yet on the lot, but are on their way. And the FTC said something very strange in the NADA webinar about that, in my opinion, where they basically said, look, that's okay as long as it's very rare and it's no more than, and you're sure it'll be there no more than 1 or 2 days later. Now, I don't know where that came from. By the way, the FTC is going to be they said they're going to put out some FAQs. So I hope that's when they clarify, because I think that's overstepping reality a little bit. And I don't think that's right, but he said it. So I'm passing it on to you. He said you could advertise in-transit vehicles as long as it was relatively rare and you were sure it was going to be on the lot in no more than 1 or 2 days. Now, I don't think that's practical. I don't think that's reality. I'm not even sure that's what they want. But he sort of an off-the-cuff answer, so I am passing it on to you. Again, this is not necessarily related to price. This is, although it can be, because it could be a phantom loss leader kind of ad. But really, they say this in every enforcement action, every time they go to Congress. It's terrible for a consumer to have to go all the way to the dealership only to find the vehicle's not there, right? And then, of course, they say you bait and switch them into another car. And so, look, what are the questions we get here? A couple things to take away. I would say in-transit vehicles are probably okay, although I note what the FTC said. Stay tuned for their FAQ. But make sure it's very, very, very clear that vehicle is in transit, right? Don't just put in transit in the footnotes or hover over text or some pop-up or something like that. I would make it incredibly clear. Put it in the picture itself, in transit. In fact, I'd arguably would put the date that it's going to arrive, if you can in any way say that. So I don't want to tell you that you cannot do it or that it has to be no more than 1 or 2 days, although it's what they've said. But I would make sure that you are very clear. And the same thing if you have, a website that advertises vehicles on multiple locations. Make sure it's very clear which lot this is on, right? This is on the lot here, not the lot that's 50 miles away somewhere else, right? The harm they're trying to get at is someone goes there to look at the vehicle and it's not there. What about cars that are actually sold, right? I get that question every time. Well, the answer is you should be doing things to make sure that your feed is updated pretty darn quickly, I would say. I think most of these systems you can automate to no more than a day or two. But a couple of things I would say. I would have some sort of disclaimer in all my ads that says advertised price is good until midnight on whatever date. Have some sort of time frame on it, and make sure that you take vehicles that you actually sell off of the website. I see a question here, and I'll just answer real quick. Somebody says, "What about a vehicle that you took a deposit on, but it's still sitting there, or it hasn't yet arrived? Do you have to take it off your website?" It's a good question. I guess I would say it depends on what deposit means. I mean, if you're taking a deposit, if taking money from someone as a deposit reserves that vehicle for them, they get an unreserved right to buy the car from you, then yeah, you should take it down from your website, right? Because that's arguably, even though it's not finally purchased, it should not be offered for sale to other people. if there are deposits, I mean, if it's a deposit that's just like, hey, I'm putting my deposit down on the 2027, brand new version of this car that hasn't even been made yet, that's a whole different question. But I think, yes, if you've taken a deposit and that deposit means that person could unreservedly buy that vehicle, I'd take it down from your website. So that's a good question. Again, make sure in transit is not a little tiny thing. It's big, it's prominent, it's bold. Okay. And again, if you know when it's going to be there, I'd put it on there. Last thing I'll tell you, this one's interesting. We see this all the time in these websites where people think they're protecting themselves by putting language like, all vehicles subject to prior sale may not be available or on our lot, or check for availability or whatever it might be. I would not do that, because I think the problem with that is you've arguably just put into question whether any of the vehicles on your website are actually on the lot, right? You can't advertise a vehicle if it's not available. And so you may be thinking that protects you, but I think you could actually get yourself into trouble because it's confusing. I'm a consumer. I'm like, well, wait a minute. Do I drive all the way over there? Is it there or not? Right? The onus is on you to kind of make sure that you can tell people. Okay. I spent a lot of time on that one, but that's an important one. So yeah, those are the 6 issues. And again, I can't see if there's any questions. That this might be a decent time to ask if we've gotten any other ones in. But I got some examples here just to go through it. But look, I think you see the common theme. Common theme is the price has to be the price that I can come in. I think the FTC person said you can come in, write a check, and walk out the door for that amount plus taxes and title and license. Okay, so that's what they want to do. So if there are no questions to that, or unless you want to jump in, Ann or Rachel, but let me give a couple examples because sometimes it helps to see. Now, I want to say a couple things. These are from our advertising guide we put out. I have a link at the end. You can go download this if you want to see. It's actually very comprehensive. It's long, but keep in mind, these are not perfect ads. Like the one on the right is green, compliant, but it's compliant for the total price issue. Not like you'll see it doesn't have a bunch of other stuff in here. It's not intended to be perfect. It's just sort of showing you how do you disclose the price, right? The one on the left, you can see what is the price of that car? Looks like it's $32,995, right? But there's an asterisk. There's a very small mouse print below that says exclude $799 documentation fee. So that's the problem. That is exactly what the FTC is saying you can no longer do. It is not $32,995. It's $32,995 plus $800. It's $33, whatever that is, $794. And so you cannot. I'd say that. I would also argue that little box that says get today's price. There's a question about that too, because what is the price? Is that the price, or is that or is $32,995 the price? Neither of them are the price, really. No one can come in and pay that price for the car. So that's a problem, right? That's the basic fundamental thing they want to get over. The one on the right, again, it's not perfect in all ways, but this is intended to be an example of a way to disclose the price properly, which is it says all in price. I mean, you can use that term. There's that, maybe you say total price. There's nothing saying you can't say Miller Motors price, whatever you want to call it, but it has to be the biggest, boldest, most prominent number, and it has to include all dealer fees. And again, I like this. I like this in particular. It's got the little green check underneath of it. Very prominently says includes all dealer fees, but excludes tax, title, and registration. Right. So I'm not saying this is a perfect ad in other ways, but that's essentially what they want you to do. Put the doc fee in the price. Okay. Next example, rebates. This is a little easier when you see it in writing. And again, these two don't go together. So don't try to do the math. It's going to come. Let's look at them individually. The one on the left is what they're trying to get you not to do, right? MSRP 52,500. Costco member offered loyalty rebate. You can read all those things. And then what they do is they take all those numbers. First of all, you got a rebate stacking problem, even under today's laws in this ad. But, then you got that big bold price up on the right, 41.5 with the asterisk that says price reflects all available incentives. Not all customers will qualify, must provide proof of eligibility. See dealer for details. So dealers will say, look, I told them it's not everybody qualifies. I've disclosed it. Isn't that good enough? The answer is no, it's not good enough. You cannot take those numbers if they're not available to everyone and factor them into the price. You can't do the math for them and say 41.5 because 100% of the people cannot walk in and stroke a check for 41.5 plus taxes and walk out. Okay. So that's the way you can't do it. The one on the right is probably is a better way. Again, this is not, don't look at them together other than to look at the way they did the rebates. There is a asterisk by the price, but it's just because it says excludes government fees and taxes. But none of those rebates that are available have been factored into the price. That is just the price you can buy it for. And it lists each potential rebate with a little bit, those parentheticals are important. You have to have, they do say you need to have some explanation of what the qualifications are for each rebate. So you get the idea they're active military, but you need a military ID, etc. So it doesn't have to be, exhaustive 15 sentences, but it has to be something with some limitations. Okay. So that's rebates and conditional pricing. Here's two that are, so one's conditional pricing, one's mandatory add-on. So the one on the left, if you look at the Accord Sport, so it's advertised, the advertised price sure looks like it's $28,995, but that price includes the $1,500 Honda Finance bonus cash. That requires you to finance through the dealership. That's not available to everybody, so you can't factor in the price. The car is actually, whatever that is, $30,495. Right? It's not, there's cash price $34,495 is actually in the fine print. So that's what they're saying. You cannot vary a rebate that requires you to finance through the dealership. You have to have it in the price. The one on the right is an example of what you cannot do with respect to add-on products. So you get the idea here. The car looks like it's $42,995, right? Looks like it to me. But if you look below in the fine print, Pro Tech window tint, low jack theft recovery, all weather floor liners, et cetera, there's probably $3,000 worth of accessories, and it says installed accessories not included in the advertised price. So you can't buy this car for $42,995. Now, if it was really just the floor liners and it didn't say, and said they were optional, maybe that's fine because again, those you can actually take in and out. But this is a good example. I mean, it's, illuminated running boards, window tint, door edge guards, low jack, those are pretty much mandatory add-ons. Don't do it that way. This is the way not to do it with respect to add-ons. Okay. Very quickly, availability, deceptive claims. Yeah, this is kind of a bad example because you can't even tell from this other than the fact that this car is not even actually on the lot. So so this is not taken out of context. So it's kind of hard to tell. But yeah, basically you can't. This car, the price is fine. The actual, although there's no explanation of the savings, and assuming that was available to everybody. But the problem with this one is, the vehicle pictured may not represent an actual vehicle. All vehicles subject to prior sale, etc. Contact dealer to verify availability. This one actually wasn't actually at the store. So you can't advertise a vehicle that's not there. Now, if it was in transit, could you have in transit on it? Probably, but see our discussion earlier. And then finally, here's an example of a way to do an in-transit vehicle. I think that's probably better. So you get the idea. The big in-transit is in the picture itself. And then under you've got the MSRP listed. Now, I will tell you, this is actually, it's funny. I see this ad, I would say, is actually another problem because there's no price listed on this. But again, this is not for the price piece. This is just for the in-transit piece. Look at the in-transit, and it says status in-transit estimated arrival April 22nd, 2026. So that's probably, again, there's nothing saying this is the only way. There's just an example of a way that you could do it more clearly. Okay, so I can't tell Rachel or Ann if there's any questions. I'm glad to answer them, but if not, I'll just very quickly touch on what should you do now. Obviously, you should be prepared for more enforcement. Look, I think that's unfortunately going to be the reality. They couldn't send a stronger signal, and they're going to be following up with enforcement actions, especially for dealers who don't change their ways pretty darn quickly. Again, this is not do it by July 1st, do it by January 1st. It's do it now. What should you be doing? Maintain vigilant oversight of your price advertising. Make sure that you understand that the prices that what they are on your website, not just your own website, but also third-party sites. Always get questions about that. Look, you give the price to a third-party site just because it shows up on another third-party site. You are going to be responsible for violations in that ad. Now, always get questions about, what about my OEM? My OEM's putting ads on my website for vehicles I don't even have in inventory. Well, that's a problem. That's a problem. And you are going to be held responsible for it. But I mean, look, you'll have a defense. You go ask your OEM to indemnify you for a problem they created. But look, you got to have a conversation with them. We certainly are talking to some OEMs. I'm sure NADA as well. Hopefully, they'll make sure that they're on top of that, because I've heard that for years, that the OEMs are putting ads on my website that I don't even control and have issues. And so, just be aware. It doesn't matter where it comes from. If it's on your website, if it's something you're responsible for, you're going to have a problem with it. All fees and products are disclosed, not in the fine print. I'm not going to read all this stuff to you. We've kind of covered all this stuff. Look, implementing robust compliance tools and systems to monitor your best practices, you have to do something. Because the problem is VDPs are changing all the time. You change prices in your ads. You sell vehicles. You got to update this stuff. It's in different places. It's on social media. By the way, ads are not just your VDPs or your websites. It's if it's on social media, if it's in print, if it's on radio, if it's on a sign on the car, right? I mean, theoretically, those are all advertisements, and these guidelines apply to all those things. Again, advertise the out-the-door price or clearly state the exclusions, right? Establish an advertising review process. Look, consider a reasonable consumer. What would they think? I mean, I've said this for 20 years. It's like, look, what would your, use the grandma test. What would my grandma think the price of this car was? And from this advertisement. I mean, that's kind of the way that they look at it. And I think that's probably as good a test as any. I won't go through all these. Is the vehicle advertised available on the lot? Now, the last bullet, I will note one thing, because I don't think I touched on this. They actually said, oddly, in the letters to the 97 groups, that you should have records to show that the price you sold it was the same as the advertised price. Now, I think that's actually wrong. I think it has to be the advertised price or lower, right? So it's a ceiling, not a floor. In other words, you advertise the vehicle for $50,000. You can always sell it for less. I don't think there's anything prohibiting you from negotiating a price lower than that with the consumer. You cannot, however, sell it for more than $50,000. Now, Brad, wait a minute. $50,000 vehicle, the retail installment sales contract is going to say $53,500 because they bought a service contract and they did finance. That's fine. The overall transaction can be more than 50. It's just the vehicle itself can't be more than 50. Okay. So having records to prove that probably is a pretty good idea. We do have tools to help you with that, but I don't have time to talk about it today. I mean, talk to us about our Guardian product. I'll touch on it for 2 seconds here in a second, but do an audit of your advertising. Look, you got to do this. Work with your third-party vendors. Make sure this stuff's updated. Make sure your sold vehicles are taken down in a timely fashion. It's going to take some work. Review the price promotions, the rebates, the discount programs. Look, your teams are going to push back on this because they've done things a certain way for 30 years, right? So I get it. So you're going to need to train them. You're going to make sure they understand that the pricing that has to be compliant, that their teams are not saying anything that contradicts that no mandatory products are excluded from the advertised prices. Okay, so I'll wrap it up. I don't know if there's questions if you want to read them, but if you want, this has been very popular. We put out this guide and we updated it for these enforcement actions and the letters. If you scan that QR code or go to our website, you can find it. It's no charge. Just go get a copy if you want. It's got that's where a lot of those examples I showed came from. There's more examples in there. It covers more than just the letters, but it does cover the letters as well. So go get a copy of that if you're interested. And very quickly, again, this is not to talk about our products, but frankly, we've had this product for about a year. It basically will scan your VDPs, utilizing our software and AI, and will identify all issues in your ads under all 50 states and federal law and allow you to fix them. It's a very, very powerful tool. It's been very popular. call us. I don't go into the details, but call us or scan that to have a demo. Reach out anytime. It's been very popular, as you can imagine. Right now, we're very busy, but we've made it available right now to dealers, and we want to get it in your hands because it's a very, very powerful tool. So again, ComplyAuto, we do more than that, and just so you know, all the things that we do. But I'm here to answer questions. I probably have already taken. Yeah, we've already hit 52 minutes. I know that was a lot, and it's always hard when I can't see your faces. Hopefully, I'm keeping you all engaged. If there are any questions, Rachel or Ann, I don't know if you. I can't see them, but if you want to read them to me, I'm more than happy to answer.
Brad, there's one that just came in. Let's see if I can get it here. Asking for clarification regarding itemized price stacking and call for price advertising.
Yeah, I mean, okay. So say it again. Itemized. Say the last.
Clarification regarding itemized price stacking and
Itemized
call for
price
price
stacking.
advertising.
Itemized price, call for price. All right. So itemized price stacking. So I think maybe what we're talking about is rebates. So rebate stacking. So right. So here, I'll go back up to the example ad that I had. That's why this makes it a little bit easier. So the one on the left, the one that's red, that's pink. So rebate stacking is there have been enforcement actions brought for years for rebate stacking. You can't list a price that nobody can qualify for all the Costco, GM, Conquest, Trade-In, and if no human being could qualify for all those, it's always been presumptively illegal to stack those rebates that way. That's what rebate stacking means. What they're saying now is you cannot take any of those rebates and subtract them from the price, this 52.5, unless all consumers qualify for them. So you can't do that for the Costco member offer because not all consumers are Costco members. You can't do it for the GM loyalty rebate because not everybody's a GM, currently owns a GM car. You get the idea. Conquest cash, no. Trade-in assistance, no, because not everybody's a trade-in. Dealer discount, maybe if you offered the dealer discount for all consumers, then you could take it out of the price. But you can't take all these rebates, subtract them from 52.5, and then put a big headline number of 41.5. That's essentially the problem with rebates and the thing that they're trying to get at. Because someone walks in and says, I want that car for 41.5. You say, well, that's great, but you don't qualify for A, B, and C. So your price is 48.5, right? And they found that to be deceptive. That's the issue that you have to avoid. Now, on the call for price, that's a little bit more. I think I had an example of that too. Yeah, if you look at the one on the left, and I kind of alluded to this. This is a little bit. There's an open question. I didn't touch on this because the FTC hasn't said this specifically. I usually get this question: do I have to have a price on every car I advertise? The answer is, I think probably yes. Now, they didn't specifically say that, but I think it's pretty clear that they would find it to be deceptive to advertise a specific vehicle without any price for it, right? Now, you could probably advertise, hey, we have the new F-150 Raptor in stock. That's probably okay, or if you have two or three of them. But if you're advertising a specific vehicle, I think they'd want you to have a price. And if you have a button that says "Get today's price" or "Call for price" or you only list the MSRP, but then you have a click for price kind of a thing, sort of MSRP only advertising. You really don't have a price, right? There's no what's the price of this car on the left here. The pink box. It looks like it's $32,995, but do I have to click this box to get the price? And they've sort of said that's deceptive because the price has to be the price that includes all the fees. B, if there's another price that's available to everybody, then it's available to everybody. And if it's not, you can't advertise it, right? So the whole notion of get today's price, and you probably click on that to lead form. I think the one on the right that says call for details, that's probably okay because you can have a call to action. This is call to details, but I would not tie it to the price because you're running into an allegation that I think that your price that they haven't displayed the actual total price for the vehicle in the ad. So hopefully that answers that question. It's a great question.
Thanks, Brad. In the
Sure.
interest of time, we're going to cut off questions for now, but you can always email them directly to me or to Brad at brad.miller@complyauto.com.
Yep.
Brad, I know you're a really busy guy over there in this ever-changing environment, so we really appreciate having you on. Thank you so much. Again, all of you that are on the line now, you'll be receiving a copy of this webinar and the slide deck by the end of this week, early next week. And if you'd like, you can join us back here again on Tuesday, May 12th at 2 p.m. Eastern as WarCloud talks how AI is bringing discipline to warranty operations.
All right. Thanks so much, everybody. Take care.
Thanks, Brad. To learn more about AIADA, visit aiada.org. Thanks for joining us, everyone, and have a great day.